So one time per month for the last number of years, our company, Grace Property Management, has put out a video, and every month we address a current topic, a trend, something happening in the real estate property management space pertinent to real estate investors in Colorado. So last month we did a video which was entitled "The Top Reasons Property Managers or Landlords Get Sued for Improper Security Deposit Returns." And we talked about common practices. Well, literally a couple days after we recorded that video, the Attorney General for the state of Colorado announced on a surprise press conference a major settlement. It was a $1 million settlement against a Colorado property management company. I want to share a couple aspects of that to explain how it impacts you as a real estate investor in Colorado, regardless of the size, whether you own one rental property, whether you own a portfolio of properties. The things that the Attorney General laid out in this press conference pertain to all real estate investors in Colorado. Now, here was the headline, and we'll link to all this in there. Four-Star Realty to pay $1 million and end illegal tenant billing under an agreement with the Attorney General, Phil Weiser. Four-Star Realty is a property management company. They're a very large property management company here in Colorado, one of the largest. They manage properties throughout the Front Range from Denver to Fort Collins. And here's what the Attorney General says on the Attorney General page, which we'll link to in this here. This was in January of 2024. Attorney Phil Weiser today announced a settlement with Colorado property management company Four-Star Realty, ending a state investigation that found numerous instances of the company illegally charging tenants for routine repairs and services. Under the terms of the settlement, Four-Star agreed to pay the state just under $1 million, nearly all of which will be earmarked for consumer restitution. Here was the quote by the state attorney general, Phil Weiser. "Too often, landlords and property management companies nickel and dime tenants by deceiving them into paying for things like normal wear and tear or damage from previous tenants, or by charging fees not reflected in the lease." He wanted to say a number of other items there. There's a 17-page signed stipulation and complaint, which we'll also link to. Here's why this is important for you, whether you own one rental property or whether you have a portfolio in property management companies, because the things that the Attorney General found apply across the board. They don't just apply to large property management companies. They apply to real estate investors as it relates to primarily security deposit returns. That's what the really foundational piece of this was. And there were two things in the front of this stipulation that they stated. They stated that they were unlawfully withholding money from tenant security deposits, number one. And then secondly, they were charging very unfair and deceptive fees. So let me just share a couple pieces of information right out of the settlement to help you as a real estate investor ensure that you're navigating and you're properly following the laws as it relates to security deposit returns in Colorado. That's the reason we did this topic last month on our video, because it's confusing to real estate investors, primarily around the understanding of mischarging things to tenant security deposits that shouldn't be charged. So this was one of the things that they said in their stipulation. They said that what this company would do, what Four-Star would do, is they would place all the expenses on the tenant's ledger initially, only later going back to subtract charges that should be borne by the owner. So the company was starting, in reading the whole stipulation, the company was kind of starting from the premise of, gosh, how can we keep as much of this tenant security deposit as possible? The security deposit legally belongs to the tenant. And state law is very clear that you can only withhold for things that are direct damages or charges that are owed to the landlord. You can't start from the place of, well, let's keep as much as we can and then give back what we have to give back. That's the exact opposite of the mentality that the law requires. It should be the goal of the property management company to give back as much as is possible to that vacating tenant and only retain that which is legally permissible and owed, whether it be damages or legitimate fees owed to the property management company. They went on to say this. They said these were some examples of charges that the property management company charged against the tenant security deposit that they're saying these things are not legitimate, they should not have been charged. They charged for assessing the condition of garbage disposals. So just to look at the garbage disposal and to determine what's the condition, maybe there'd be a fee for that. They charge for things like caulking the tile in the kitchen and the bathrooms. That would be a wear and tear item. That's not damage. Caulking just wears out over time. That should not be charged to a tenant security deposit. They charge for painting walls when the tenant may have caused only minor scuffs or scratches. That's a big part of the stipulation, was around charges for painting, which were incorrect. Painting is a very hard thing to navigate because paint does wear out, and if it's just wearing out because of wear and tear, even including, as they specifically said, small scratches or indentations. They also charge for fixing loose doorknobs. That's a wear and tear item. Something else they were charging for: tightening door hinges and toilet seats, cleaning air conditioning filters, cleaning vent fans. There was a lot of cleaning. So much of this had to do with charging for things that were around cleaning that they really probably shouldn't have been charging for, and charging for things around painting, which, as the state has been very specific, that is considered wear and tear. They went on to say this: in some instances, they would paint an entire wall, even if the only imperfection on the wall was superficial scuffs, minor indentations. That means tack holes in walls for hanging things. Landlords, property managers, real estate investors, you cannot charge your tenant security deposit for the tack hole in the wall where they hang their picture. They've specifically stated that. That would be considered a minor indentation or faded or peeling paint. They went on to say this. They wanted to make this point. They said annual repainting between tenancies to address things like scuffs, small isolated holes or indentations, peeling or faded paint, or simply because the landlord wants the walls freshly painted for incoming tenants, is precisely the sort of normal wear and tear landlords are not allowed to withhold. This is a very common practice, unfortunately, in the industry. It's wrong when landlords or real estate investors will withhold from the tenant security deposit for painting charges incorrectly. They also said they overcharged tenants for cleaning, and they said that there were baseless and undisclosed fees. You cannot charge a fee to a tenant on their security deposit if it is not clearly disclosed in the lease agreement. If there's a fee that's in the lease agreement that is owed to the property management company or the real estate investor, then that's fine, that's legitimate, but it has to be legitimate, it has to be provided to back up to that tenant upon them moving out of the property. They went on to say this: the company doing most of the maintenance is also owned by the same owners of Four Star Realty. Now, this is not illegal, but it does raise an eyebrow. So the company would send in a maintenance company to do these repairs, and this maintenance company that they would send in to do the repairs was owned by the property management company themselves. Now, as I said, that is perfectly legal as long as it is disclosed, but it does raise an eyebrow because it looks suspicious. So for our company, Grace Management, we don't do in-house maintenance. We use third-party vendors. We want there to be a clear separation that we're not profiting as a company for repairs that are being done on the properties. We don't own any property or we don't own any companies that are doing routine maintenance. That there should be a separation, not illegal, must be disclosed if they're doing it. This is very, very important because if you are a real estate investor, those things apply to you. We'll link to everything in there. If you're a client of Grace Property Management, you can rest assured that we pertain and we do all security deposit returns in full accordance with the law. If you're a resident, a tenant of Grace Property Management, we want to get you back your full deposit as the law requires, and we want to help real estate investors and residents in this problem. If you've got questions, if we can be a resource, jump on our website, rentgrace.com. We're happy to help if we can.